Welcome back. In part one of my top tips, I covered getting familiar with the court process, not getting bullied by your ex's legal team, and not being afraid to ask the judge to explain matters. So today, I'm going to cover 3 more top tips to help you with representing yourself in the family court. Top tip number 4, make sure that you have your say in court. Hearings, and in particular remote hearings, which I will cover in more details in a later video, are all too often dominated by the judge and the other party's barristers who love the sound of their own voice. It can therefore be very difficult to get a word in edgeways. The judge may typically ask the barrister to update him on where we are with things, and the barrister will jump at the opportunity to put his side of the case to the judge in a very clear and long-winded way, as though there is only one side of the case. The judge may go through various key points of the case, and the barrister in turn will take over forcefully making his points. Good judges should turn to you after each point and ask your position and view. This is your chance. You must put your point across as clearly as possible, and if you disagree with the barrister, which you surely will on many points, you must say so, and also correct any of the outrageous lies that the barrister will surely make about you and your case. However, the judge may just try and rush the hearing through without you having your say or putting your case across. This happens far too often, particularly in remote hearings. I hear far too often from people that the hearing just flew by and they weren't given the chance to say anything, and as a result, the outcome of the hearing was highly one-sided and unfair. Don't let this happen to you. If you're at the court, make sure that the judge is aware that you want to speak. You can put your hand up, catch his eye, and ask if you can speak. Don't talk over the judge or barrister. However, when there's a lull, make sure you register your intent to say something. If you're on a remote hearing, simply keep your hand up until the judge registers that you want to speak. Top tip 5. Learn how to write an effective position statement. You should always submit a position statement prior to the hearing, so that the judge or magistrate fully understand what your position is, what the issues are, and what you're proposing is in the best interests of your children or financial settlement. I've seen many position statements written by clients over the years. However, it is rare that I've seen an effective statement. Unfortunately, people typically submit reams of paper, making all kinds of claims and allegations against their ex in a highly random and contentious manner. It is understandable why the statement is written in this way, as you are typically speaking from the heart. There is often a high level of conflict and acrimony. You have a lot at stake, and you want to make sure that the court is clearly aware of this and how unfair and nasty your ex is. Unfortunately, this is not what the court wants to hear, and they will pay little attention to a statement written in this manner. You don't know that, or you've been trained to know otherwise. You need to learn how to produce an effective statement. Your statement should be concise, no more than 2 to 3 pages. It should be set out in clearly defined sections to summarise your position in a way that is easy for the court to understand. I suggest that you research how to write an effective statement, or contact me for a copy of a position statement template. I'm also making a short video on how to write an effective statement, so subscribe below to ensure that you are notified when it's available. Top tip number 6. Read and digest your court orders and notice of hearings. I hear all too often from people that nobody told them, or they forgot to send a certain document to the court. They were late sending their statements. Didn't realise that the hearing was remote. I was asked totally out of the blue if I'm ready to exchange my documents. You must pay good attention to the court order. It's there to help. It clearly tells you what the next steps are of your case, what documents have to be produced, and when they have to be filed at the court and served on the other party. It is therefore extremely important to read and understand the order, particularly under the section that starts with the court orders, as that section will tell you exactly what you have to do next and it is therefore really important to take note of the deadlines that you must make. Make life less stressful and a little easier for yourself by making a note of all the court dates. The order is there to help you, so read it, digest it, and make notes. Thank you. I hope that's helped, and see you very soon. Bye for now.